Today we are discussing the new topic of alienation of coparcenary property. That is the topic of power of Karta to sell coparcenary property. I am discussing this topic with reference to a judgment delivered by the Supreme Court of India in the case of Arshanur Singh versus Harpal Kaur. It is a division bench judgments given by the two judges, namely Honorable Justice Uday Umesh Lalit and Honorable Justice Indu Malhotra. This case is reported in the All India Reporter year 2019 Supreme Court, page 3098. The facts of this case is there was one common ancestor named as Inder Singh. Inder Singh was having three sons, namely Guru Charan Singh, Dharam Singh and Swaran Singh. So that common ancestor Inder Singh and his three sons, there was a partition between them in the year 1964, and as a consequence of that partition, that Inder Singh and his three sons got equal 1/4 share each in the entire coparcenary property. This present case is relating to that share which Dharam Singh has got in the partition. That Dharam Singh had only one son, that is Arshanur Singh, who is appellant in this case before the Supreme Court. That Arshanur Singh, who is a son of Dharam Singh, was born in the year 1985. That Dharam Singh purportedly sold the entire suit property to respondent number 1, that is Harpal Kaur, while two registered sale deeds effected in the year 1999. So, by virtue of the partition which took place in the year 1964, father of the appellant Dharam Singh got 1/4 share, and that 1/4 share, that entire property of that 1/4 share, Dharam Singh has sold it by a registered deed in the year 1999 to the respondent number 1, Harpal Kaur. Here it is to be noted that appellant Arshanur Singh, who is the son of Dharam Singh, was born in the year 1985, and after his birth, later on in the year 1999, his father Dharam Singh sold entire suit property which came to his share upon the partition. Then the appellant became major in the year 2003. That means at the time of that alleged sale in the year 1999, that appellant son Arshanur Singh was a minor. So he became major in the year 2003. Therefore, in the year 2004, the appellant Arshanur Singh filed a suit for a declaration against his father Dharam Singh, as well as against the transfer of that Dharam Singh, that is Harpal Kaur. Suit for a declaration that the suit property was coparcenary property, and hence those sale deeds of the year 1999 executed by his father Dharam Singh in favor of respondent number 1 herein Harpal Kaur, those sale deeds were illegal, null and void. So it is a simple case. Arshanur Singh filed a suit for declaration that those sale deeds effected by his father in favor of that Harpal Kaur, those sale deeds were illegal, null and void. Why? Because this property was a coparcenary property and he was also having share in that property. The trial court, that is civil judge, decreed the suit in favor of the appellant, plaintiff Arshanur Singh. The trial court held that the suit property was ancestral property of Dharam Singh and the appellant, ancestral property of the Dharam Singh and the appellant Arshanur Singh, and that Harpal Kaur transferee purchaser Harpal Kaur failed to prove that Dharam Singh had sold the suit property to her for either legal necessity of the family or for the benefit of the estate. Consequently, those two sale deeds dated of the year 1999, purportedly executed by Dharam Singh in favor of the respondent number 1 Harpal Kaur, were illegal, null and void. So this was the finding of the trial court. Therefore, that purchaser transferee Harpal Kaur filed an appeal before the district judge. The district judge dismissed the appeal, means district judge confirmed and upheld the finding of the trial court. So district judge dismissed the appeal. The district judge also held that in the absence of any legal necessity or benefit to estate of the joint in the family, the sale deeds of the year 1999 were illegal, null and void. Therefore, agreed by the order of the district judge, that respondent Harpal Kaur and other respondents means Father Dharam Singh. Those respondents filed appeal before the Punjab and Haryana High Court. While this appeal was pending, the father of Arshanur Singh, Dharam Singh, expired in the year 2017, who was respondent number 2 in that appeal before the High Court. The High Court, while its judgment dated 13 November 2018, allowed the appeal filed by the respondents and set aside the concurrent findings of the courts below, that is district judge and civil judge trial court. So High Court allowed the appeal filed by that Harpal Kaur. The High Court held that in that appeal, the appellant Arshanur Singh had no locus standi to institute the suit, since the coparcenary property ceased to exist as a coparcenary after Inder Singh partitioned the property between his three sons in the year 1964. So why, on which ground High Court allowed the appeal filed by the respondent? That appellant Arshunur Singh, appellant in this appellant before the Supreme Court, the appellant Arshunur Singh had no locus to institute the suit. Why? Because the coparcenary property ceased to exist as a coparcenary property after the Inder Singh has partitioned the property between his three sons in the year 1964. And agreed by this impugned judgment and order dated 13 November 2018 passed by the High Court, the appellant Arshunur Singh has filed this present civil appeal before this Honorable Supreme Court. So in this present civil appeal, Arshunur Singh is the appellant and he has filed appeal against the respondent Harpal Kaur, who has alleged to have purchased the property from the father of Arshunur Singh, that is Dharam Singh. So the issues that arise for consideration before the Supreme Court are two issues. First issue is whether the suit property was a coparcenary property or a self-acquired property of the Dharam Singh. And second issue is relating to validity of those sale deeds of the year 1999 executed by Dharam Singh in favor of the respondent number 1, Harpal Kaur. So what was the issue before the Supreme Court? In this case, whether the suit property was coparcenary property or whether it is a self-acquired property of Dharam Singh. And second issue is regarding validity of those sale deeds. While dealing with this issue, especially the first issue, whether it is a coparcenary property or self-acquired property, with respect to the first issue, the Supreme Court referred the commentary on Hindu law, that is commentary on Hindu law by Mullah, 22nd edition. In that commentary, the position of law with respect to succession under Mittakshara law is stated as under. Commentary on Hindu law by Mullah's commentary on Hindu law. What is the legal position? A son, a grandson whose father is dead and a great grandson whose father and grandfather are both dead succeeds simultaneously as a single heir to the separate or self-acquired property of the deceased with rights of survivorship. But the important aspect of it is stated further. That is important part. What is important? All property inherited by a male Hindu from his father, father's father or father's father's father is ancestral property. So Mullah in his commentary on Hindu law says that all property inherited by a male Hindu from his father, father's father or father's father is ancestral property. The essential feature of ancestral property according to Mittakshara law is that the sons, grandsons and great grandsons of the person who inherits it acquire an interest and the rights attached to such property at the moment of their birth. So, sons, grandsons and great-grandsons of the person who inherits the property from its ancestors acquires an interest in such a property at the moment of their birth. A person inheriting property from his three immediate paternal ancestors hold it and must hold it in coparcenary with his sons, and sons' son. A person inheriting property from his three immediate paternal ancestors holds it in coparcenary with his sons, and sons' son. The share which coparceners obtain on partition of ancestral property is ancestral property as regards his male issue. A share which a coparcener obtains on partition of ancestral property is ancestral property as regards his male issue. After partition, the property in the hands of the son will continue to be ancestral property, and the son of that son will take interest in it and is entitled to it by survivorship. So this is the legal position as it is made clear in this commentary on Hindu law by the Mullah. So on this background, in the present case, Supreme Court observed that the coparcenary property was partitioned between the three sons of Inder Singh in the year 1964. The shares allotted in partition to the coparceners continue to remain coparcenary property in their hands qua their male descendants. As a consequence, the property allotted to Dharm Singh in partition continued to remain coparcenary property qua the appellant. So it was observed by the Supreme Court and held by the Supreme Court that in our present case, whatever that 1/4 share property was acquired by the Dharm Singh by way of partition, that property continue to remain coparcenary property with regards to his son Arshunur Singh. So with respect to the devolution of share acquired on partition, share which is acquired on partition, Mullah on Hindu law in his 22nd edition also states that the effect of partition is to dissolve the coparcenary, with the result that separating members henceforth hold their respective shares as their separate property, and the share of each member will pass on his death to his heirs. But however, if a member, while separating from his other coparceners, continues joint with his own male issue, then the share allotted to him on partition will, in his hands, retain the character of a coparcenary property as regards the male issue. So, position is clear. If a member, while separating from his other coparcener, continues joint with his own male issue, then the share which is allotted to him on partition will in his hands retain the character of coparcenary property as regards his male issue. Therefore, it is well settled position that, legal position that, the share which a co-sharer obtains on partition of ancestral property is ancestral property as regards his male issues. They means male issues, take an interest in it by birth, whether they are in existence at the time of partition or born subsequently. So share which any co-parcener obtains on a partition is an ancestral property as regards his male issues, and those male issues take an interest in it by birth, then it is not relevant here whether they were in existence at the time of partition or not. It is not relevant. Even if those male issues are born subsequently, then also they will have an interest in that coparcenary property. So in the present case, the suit property which came to the share of late Dharam Singh through a partition remain coparcenary property as regards his son, that is appellant herein, who become a coparcener in the suit property on his birth in the year 1985, and therefore Dharam Singh, and thereafter the Dharam Singh purportedly executed those two sale deeds in the year 1999 in favor of the respondent Harpal Kaur. That is, he sold it after the appellant became a co-parcener in the suit property. So when appellant became co-parcener upon his birth in the year 1985, and when his father sold the property in the year 1999. Therefore, the Supreme Court in this present case held that the property which Dharam Singh got in the partition is the co-parcenary property. It is not separate property of the Dharam Singh. It is a co-parcenary property as regards to his son Arshanur Singh. Then the second issue which has arisen for consideration before the Supreme Court is relating to the validity of those sale deeds, of the year 1999, which were allegedly to be executed by Dharam Singh in favor of the respondent Harpal Kaur. So regarding this second issue, the Supreme Court in this case observed that it is settled law that the power of Karta to sell coparcenary property is subject to certain restrictions. What are those restrictions? The sale should be for legal necessity or for the benefit of the state. Means Karta can sell coparcenary property, but subject to restrictions. And what are restrictions? He can sell the coparcenary property only for the legal necessity or for the benefit of the state. And the onus for establishing the existence of legal necessity is on the alignee. So, in case of suit proceeding before the court, on whom there is a burden to prove the fact of legal necessity, it is a alienee, it is a transferee, it is the purchaser. They have to prove it that seller has sold the coparcenary property for the legal necessity. So legal necessity to support the sale must however be established by the alienees, that is purchaser. The onus of proving legal necessity may be discharged by the alienee. Alienee means transferee, purchaser. The onus of proving legal necessity may be discharged by the alienee by proof of actual necessity, or by proof that he has made proper and bona fide inquiries about the existence of the necessity and that he did all that was reasonable to satisfy himself as to the existence of the necessity. So this point is very important. When you wish to buy any land property from any joint Hindu family, when you wish to buy the ancestral property of any joint Hindu family, then firstly you must satisfy yourself that whoever co-partner is selling that ancestral property belonging to his family, he is selling that property either for the legal necessity or for the benefit of the state. So he is selling his property for the legal necessity. The purchaser has to find out the existence about the legal necessity. For that purchase, the purchaser has to make necessary inquiries why the seller is selling the co-personal property belonging to his family. So the burden is on the purchaser to make inquiries about the existence of the legal necessity. Then only he should go further for this purchasing land property. So in the present case, the onus to prove the legal necessity was on that purchaser alignee, that is Harpal Kaur, to prove that there was a legal necessity or there was the sale is for the benefit to the state, or that she had made bona fide inquiries regarding the existence of the legal necessity or benefit of the state. But it was the finding given by the trial court on the fact of this proof of legal necessity. The finding is that alignee purchaser Harpal Kaur failed to give any evidence about the existence of legal necessity. Meaning thereby that Dharam Singh has sold the co-personal property even without any legal necessity or even without for the benefit of any state. Therefore, on this point, the sale deeds which were executed in the year 1999 by the Dharam Singh are cancelled as being illegal, null and void. The Supreme Court in this case by its order has cancelled those sale deeds as it being illegal, null and void. Supreme Court observed that while cancelling those sale deeds, that Dharam Singh could not have sold the co-partnership property in which the appellant was a co-partner by those sale deeds. He should not have sold this property. So, the Supreme Court observed that the plaintiff in the suit before the trial court and appellant here before the Supreme Court, that is Arshanur Singh, he being a male co-partner in the suit property, was visually affected by the purported sale of the suit property by his father Dharam Singh. So Arshanur Singh was affected by that sale. Therefore, Arshanur Singh had the locus standi to file the suit for declaration that the suit property being the co-partnership property could not have been sold by his father Dharam Singh without legal necessity. Therefore, Supreme Court held that appellant Arshanur Singh was entitled to move the court for a declaration that those sale deeds of the year 1999 executed by his father Dharam Singh in favor of Harpal Kaur were illegal, null and void. Therefore, ultimately, the Honorable Supreme Court in this present case held that the judgment passed by the learned single judge of the High Court of Punjab and Haryana, being contrary to law, is set aside, and the sale deeds of the year 1999 executed by Dharam Singh in favor of respondent are hereby cancelled and set aside. And furthermore, the name of the appellant Arshnur Singh, the Supreme Court directed that, Honorable Supreme Court directed that the name of the appellant Arshnur Singh is to be recorded in the record of rights as the owner of the suit property, and accordingly the Supreme Court has allowed the civil appeal preferred by Arshnur Singh. So we have discussed this topic of alienation of coparcenary property, especially the power of Karta to sell the coparcenary property, on the background of this case law of Arshnur Singh versus Harpal Kaur. It is a judgment of the Supreme Court, and citation of this judgment is All India Reporter 2019, Supreme Court, page 3098.